that 17A is not applicable. Let me not start with that. Forget the IPC. 17A is not applicable because, my lord, 17A is not retrospective. It was not in existence the time when the offences occurred in 2015-16. Number two, assuming, my lord, 17A applies, we had already commenced, my lord, the inquiry in, my lord, June 18. Number three, even if 17A applies, it applies, my lord, only in relation to a decision stroke recommendation in the discharge of public office or public duty. And the facts, even prima facie, not in this case, show that the actions of the person concerned cannot remotely be a part, without the purport to be a part of public duty. Next, Lord, 17A has to be construed, if it applies, in the setting, Lord, of a corruption act. In other words, Lord, the interpretation which it will receive is that the idea is to root out corruption, and 17A is not a shield for the corrupt. But, my lord, a protection from harassment for honest public servants who should not hesitate to take correct decisions. In other words, my lord, it is meant to protect what we can call, my lord, an error of judgment. Because a decision may be erroneous, may not be erroneous. That has nothing to do with corruption. So, idea is to protect, my lord, an error of judgment. But the moment, my lord, there is corruption or misconduct, 17A cannot apply at all. Next, my lord, that there are several IPC offences in the FIR lodged by the police. So 17A, my lord, is neither here nor there for a final culmination of this case. Next, my lord, a quashing, my lord, filed within 5 days of the petitioner being added as an accused is completely premature and does not give reasonable time to the police to investigate a scam of several hundred crores and 482 will not lie for scuttling Milord in investigation. Right at the initial stages. And 482 Milord in the facts of this case, which is meant to be Milord, a rare jurisdiction. The Lordships have described it as a jurisdiction rarest of rare, which is not to be confused with death cases, but still described as rarest of rare. And therefore, breathing time must be available to the authorities to investigate and show the result of the investigation to the concerned court, which is the trial. But when I said official duty, Lordship may add there that I had cited judgments to show that what is the official duty, etc., what is the recommendation concerned, is to be seen at the stage of trial. It cannot be debated in a 482. Lastly, the special judge will have jurisdiction to proceed with the case even if PC Act offence goes away. I cited a judgment to that effect. Because under the Prevention of Corruption Act, PC and non-PC under section 4 below are tried by the special court. And even if one part goes away, below, the jurisdiction of the special judge remains even for the non-PC part. So, below, this argument only going around 17A, 17A doesn't really carry the matter any further, really. This is the host of things which will have to be seen. 17A by itself doesn't carry the matter any further at all.
You are saying special judge jurisdiction will remain
Will remain
as far
even
as
if
the
PC
offence is concerned.
Yes. IPC will remain. I said in the judgment.
The jurisdiction of the special judge
Will remain even if PC goes away.
because
PC remains.
because some accused will still carry
some, not only some.